Welcome back to the channel. Today we're taking a look at a case where a man is taking his ex-wife back to court for child support payments that he overpaid for. It seems like she was hiding money. Who knows? We'll take a look at it and we'll see what the judge does with it.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. Calling case 2019-173 DC, Arthur Robertson versus Brandon Chilton. Today is Monday, April 15th, 2024 at 9 a.m.
Good morning to all of you.
Good
Court
morning.
will note the appearance of Ms. Greenlee-Clore on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for repayment of overpayment of child support. I've read the pleadings, Ms. Greenlee-Clore. Is there anything else you have to add?
The only other thing I have to add, Your Honor, is looking back at the documents, the calculation, first of all, Ms. Chilton is an intelligent woman. She knows how child support works. The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. There's no way that Ms. Chilton knew, or there's no way that she did not know that child support shouldn't have been at that level that it was at. And I don't know that's not up for debate today because it's already been modified. But at this point, my client's kind of stuck where he's overpaid child support for years, essentially, to Ms. Chilton, but he has no way to get any of that child support back. And as our motion indicated, he tried to pursue this. It didn't come back. And I think what we need to do is we probably need an order from this court with how this is supposed to get paid so that if he does need to, he can pursue collection action.
Okay.
Thank you, Your Honor.
Thank you. Ms. Chilton, what's your response?
Good morning. At the time when this was calculated, as I presented to the court, I was only working part-time, and the order was based on that part-time work ending in that summer of June or whenever that school year ended. And again, as I put in my answer, that I was not going to be working over the summer because I was going to school. And then once I went back to work in August, which, you know, I did have a full-time job at that time, that is when I submitted the documentation to the child support court that I was in fact earning more money. So I did submit documentation. I didn't understate any income. You know, we had to submit documentation to the court at that time to prove my income at that time. And so I don't feel like it is at my fault that that the child support stayed in that way. Once I submitted documentation to the court of my full-time employment, it had not changed, so I took it back to the court. I submitted it twice, as you will see in the documentation and supporting evidence that I did submit this documentation to the court twice. So I submitted, I did everything that I knew to do. I was not trying to be deceiving in any way. I submitted the information that I had that I knew that I needed to submit. And that income was based on him working more at that time. And then he went on to a different job that caused him to make less. So the recalculation, I'm not sure where the $50,000 is coming from. But again, I was not working prior to that due to COVID. And then I started working part-time, and the child care that I was asking to be paid for at that time was not being paid for. So that's when the child support came up, because he wasn't meeting his obligation that we had agreed upon.
Okay. Well, in this particular case, I'm not going to address the issue of the amount of support because that was changed and it's already been resolved. I understand the arguments, but it would be inequitable to charge the plaintiff an amount, and again, it would in essence have him paying over $7,000 that he should not have had to have paid had it been calculated at that correct amount at that particular time. So the court is going to grant the motion for the repayment. Screenly Court, what I'm going to do is order that the amount of $6,891 would be repaid over the same term that it was collected. So if it was collected over, I think you said over 12 months, then that would be repaid over 12 months. If it was longer, I just don't know based upon the pleadings that are filed, how, over what time that was collected. So I'll simply order that you can figure it out when it was collected and then have the repayment over the same term.
Your Honor, so just to clarify, dating back to the court backdated support to March of 2022. Are you saying March of 2022 to today would be the repayment period?
No, I'm saying the time that he paid the overpayment, that the repayment would be over the same term. So if it was 12 months, if it was 18 months, I don't know from the time that he began paying that $764 and the time that it changed to the 34. So it would just be repaid over the term that it was paid.
Okay, and equal monthly installments, Your Honor?
Yes.
And then no, we also made a request for attorney fees in this case. Is that
I'm not going to award attorney fees in this case.
Okay.
It sounds like there were enough issues and problems in the case to go along. I don't hold anybody responsible for that.
okay? Thank you, Your Honor.
Okay, thank you. You're free to go. You can submit that under.
I am sure this woman did not expect to have to pay the overpayment that her ex-husband had already given her. You hear stories like this all the time where the father or the mother has overpaid and it's just lost funds. It's just lost money because if you go too far back, the court can't do anything about it. So I say good for this judge for taking a stance and saying, no, he overpaid. You have to pay him back. That's fantastic.